Welcome to Cadre's companion video to the IDEA Early Intervention Mediation Family Guide. When providers and families are at an impasse, mediation might be an appropriate dispute resolution option. This video explains what mediation is, the benefits of mediation, and how it can be accessed. Mediation is described generally for Part C of the Individuals with Disabilities Education Act, or IDEA. This resource is not intended to interpret, modify, or replace any procedural safeguards or requirements of federal or state law. Often, when providers and families cannot reach agreement, collaborative problem-solving breaks down. This can get in the way of Individualized Family Service Plan, or IFSP development, and the delivery of effective services and supports for the child. It may be helpful to bring in a neutral third party to assist with resolving these disputes. Mediation is a voluntary process that brings people together to resolve their disagreements. An impartial, qualified, and trained mediator helps participants communicate with each other so that everyone has an opportunity to express concerns and offer solutions. The focus of mediation is on resolving disagreements and working towards solutions that satisfy all participants. The goal is finding solutions that meet the needs of the child and family to which all parties can agree. In order for mediation to happen, all participants must agree to participate. Participants may leave mediation at any time. When considering mediation, it is also important to know that mediation discussions are confidential. What is said in mediation cannot be used as evidence in a due process hearing or civil lawsuit. Also, if a dispute is resolved through the mediation process, a written and legally binding agreement is created and signed. It is important to note that state regulations associated with the IDEA dispute resolution processes vary widely. Parents and family members are encouraged to contact their service coordinator, state lead agency, or Office of Special Education Programs funded Parent Center for Assistance. Also, commonly used terms and additional information are available at www.cadreworks.org/EI-Family Guides. Your state lead agency must select a mediator on a neutral basis. The mediator must not have a personal or professional interest that conflicts with the person's objectivity. This means that the mediator may not be an employee of the lead agency or an early intervention provider that is involved in providing services to the child. Some states allow parents and early intervention providers to choose a mediator together. A mediator who is trained in effective mediation techniques facilitates open communication between mediation participants, creates an environment where concerns can be shared, encourages participants to be respectful and understand other points of view, clarifies points of disagreement, may help identify options, and may assist with writing down any agreement, and does not make decisions or take sides. Mediation is a problem-solving process guided by the mediator, and all decisions are made by the participants. National data show that about 70% of mediations result in signed agreements. There are other benefits to mediation too. Mediation can help everyone better understand other points of view. Also, people who know your child best work on solutions together and decide the outcome, rather than someone who doesn't know the child making a decision. People also tend to be more satisfied and follow through with the terms of mediated agreements because they are developed together. Another benefit of mediation is that disagreements may be resolved more quickly than with other dispute resolution options. Mediation also focuses on current issues and creating a plan for the future. In addition, mediation agreements are enforceable through state or federal courts and may be enforceable by the state lead agency, depending upon state policy. It is also important to know that using mediation does not deny or delay the other parental rights provided under Part C of the IDEA. A parent may still file a written state complaint or request a due process hearing to resolve the problem. There are, however, other considerations for you to be aware of before attending mediation. It is important to prepare in advance of the meeting to keep the meeting focused and make sure your concerns are addressed. Also, some complex situations may require more than one session, and there are no guarantees that mediation will lead to a written agreement. Mediation can be requested by parents, an early intervention services or EIS provider, state lead agency staff, or a public agency. A request for mediation can happen at any time, even if you have already asked for a due process hearing or filed a written state complaint. You can contact your state lead agency for more information about requesting mediation. The IDEA requires states to pay for the mediation process. In other words, parents do not pay for mediation. For more information on mediation, how to prepare for it, and how it compares to other dispute resolution options, visit www.cadreworks.org/EI-Family Guides. For state-specific information or individual assistance, contact your state lead agency or parent center. The Center for Parent Information and Resources can also assist. They provide information on a variety of early intervention and special education topics. And a current list of all the parent centers in the nation are on their website, parentcenterhub.org. For a current list of Part C state coordinators, visit the Early Childhood Technical Assistance Center, or ECTA, website. You'll find it at www.ectaCenter.org/contact/PTCCOORD.ASP. To review the Individuals with Disabilities Education Act, visit sites.ed.gov/IDEA. This concludes the IDEA Early Intervention Mediation Family Guide companion video. We encourage you to also view the Preparing for Early Intervention Mediation video, as well as the other family resources located on Cadre's website, www.cadreworks.org/for-families.